Good morning. Good morning.
Good morning.
Good morning.
Good morning.
I don't know if I'm doing this right. I don't know if I'm doing this right because I don't think you guys could hear me, or do I have to wait? Sorry.
We can hear you. And we'll just wait for the judge to show up.
We can hear you loud and clear.
I don't see Brock Benjamin on here.
Morning, sir.
Hey, Brock.
How you doing?
Just peachy. Always peachy.
There you go.
I guess I didn't have my complete view on my screen.
I had my background up. Although I saw Steven, my favorite trial attorney who the last trial I had whipped up on me. Morning, Steven.
Good morning, Brock. How's it going?
We're good.
That's my last trial, hopefully
Don't
for
quit
a
us.
while.
Come play and do some fun stuff.
I don't know about that.
Good morning, everybody. This is Robert, the court coordinator. The judge will be taking the bench momentarily.
Thanks, sir.
Thank you.
Good morning.
Good morning.
Good morning.
Wow, this is a big screen. I had a jury trial that lasted a couple of weeks on a criminal case. And I think maybe that's how I got jammed with all of you here. But let me try and move through the docket as quickly as I can. All right. You know that I'm a bifurcated court. So I do criminal and I do civil. And I end up spending more time doing criminal. And the law gives some preference to people that are in jail. But I don't want anyone to think that I'm neglecting their civil case. And if you ever want to appear in person rather than through Zoom, just let my court coordinator know. You should also know, since I have so many people here now, first of all, I've been a judge for 15 years. I was a prosecutor for 20, but I've been practicing that long. And I've COVID is what drove us to Zoom. And I've been a little bit surprised that a lot of lawyers prefer to do Zoom, and also that we have so many lawyers that are not from El Paso. But I don't hometown anyone, right, Ms. Auger? You've been in my court. I don't hometown with lawyers from other jurisdictions. I don't hometown, I just make the call the way I see it. But I'm telling you this because those of you that have pending civil cases, you sort of, and the way that I practice, you sort of drive how they progress, because I know that in the background you're negotiating or you're juggling, or maybe you're getting an advantage because of a lawyer who might not be paying such strict attention to your case. But I'm going to retire after next year. And I do, if any of you have a civil case that you want me to try, then please let Robert know. And it's very easy for me. It's a lot easier for me to get a jury trial than it is to get a criminal trial. Because I have to, for a criminal trial, I need two panels of 200 and 100 on some of the cases that I end up trying, like the one I did last week, which was child sexual abuse. Jurors you need more people in the pool. But if you want that, I can more easily impanel a civil jury, and I'll try your case. Or you can wait for the next person. I don't know who that's going to be, because registration for anyone who wants to run for my court doesn't close until December 8th. Okay? So anyways, I've got here in the order of the docket, I have Southwestern Bell Telephone Company, DBA AT&T versus El Paso Electric Company. And then I have Valerie Auger, Miss Valerie Auger, good attorney Valerie Auger. And then Rene Obregon. Who's
Good morning, Your
Rene
Honor.
Obregon? Who?
Good morning, Your Honor. Rene Obregon here for the
Oh,
plaintiff.
thank you. Okay, Mr. Obregon, where's the 361 area code?
We are in beautiful Corpus Christi, Texas.
Okay. One of these big Fortune 500 companies or whatever, you must be pretty good if they went all the way to Corpus Christi.
Well,
Who are you representing, sir?
we represent Southwestern Bell Telephone Company, Your Honor.
Okay. So this is a status hearing. It's 2024 case. And I do my status hearings. I don't know if you have a jury trial date yet, but I do have some questions so we can get this case moving. Okay.
Certainly.
But would either party like to give me the procedural status you're in right now?
If it's okay with Ms. Auger, I'll jump in, Your Honor.
Okay.
So this is a 2024 case, as you said. It's a property damage case. And I will tell you, I'm in Corpus Christi, but for a long time, we have covered a wide geographical chunk of Texas prosecuting the property damage cases for AT&T. We
Okay.
go down to the valley, we go out to El Paso, obviously, up north to Houston and beyond.
Okay.
So this case arises from an incident that happened in 2022. Most of the cases we handle deal with equipment that is under the ground. It's that equipment that's under the ground that leads to the call 811 that you see sometimes in commercials, saying that if you're going to dig under the ground, call 811 so you can figure out what's underneath there so that someone can come out, put paint on the ground, put flags on the ground, and you don't strike equipment underneath the ground.
Yes.
This one's different. This is aerial cables that were suspended on poles behind a new fire station that had been constructed at 5333 Threadgill in El Paso. On those poles, in those aerial cables, AT&T had 3 lines, 2 fiber lines and a copper cable, along with some other equipment that was suspended. And the allegation that we have brought is that El Paso Electric, in removing the poles and removing equipment behind that new fire station, went in March of 2022 and cut our lines. Our understanding pre-suit was that they did that thinking that our lines were not in use, that the utilities that were up there were not being used by anybody, and so those lines were cut. Typically what happens is AT&T tries to get these claims resolved pre-suit without the necessity of a lawsuit. If that doesn't happen, and that didn't happen here, the case makes its way to us on a pretty short time frame, and we do a very quick investigation and file suit, and that's exactly what we did here. So we filed suit in 2024, shortly before the 2-year statute of limitations. We got service completed, an answer was filed, and pretty quickly we had contact with Ms. Auger's predecessors, previous counsel, about the claim. What the claim is, sort of like this discussion, Your Honor, what the claim is, what AT&T's claim for damages is. And there was what I understood to be a mutual
Okay.
understanding.
Well, listen, Mr. Obregon, I'm sorry to interrupt you. I've heard enough to get an idea of what this is about.
Sure.
2 titans filing a lawsuit against each other. So have you all completed discovery?
We have not.
So as Mr. Obregon was mentioning, I am a second counsel in this case. Mr. Bracken was originally representing the electric company. I came in April. Mr. Obregon and I engaged in initial discussions to see if we could get the claim resolved. He allowed me some latitude in serving initial disclosures because he had been conferring with in-house counsel for El Paso Electric about the claim. And Mr. Bracken actually didn't have any real dealings with Mr. Obregon while those discussions were ongoing. And Mr. Obregon said that he would provide me information that I requested regarding the claim. And of course, it's been 6 months and it's been radio silence on his part. So I felt incumbent upon myself to go ahead and serve our initial disclosures, which he had said that we could forego spending the time and expense doing, to try to basically save money and see if we could get the case resolved.
Okay, Ms. Auger,
yes, sir.
I've heard enough on that.
Okay.
And I'm all for saving money, and I'm all for everybody, trying to do the best for their client. And I'm not that familiar with the economies involved in litigation between 2 utility type parties, but have you all, well, I'm sure you haven't mediated this.
We have not.
We have not, Your Honor.
And I
Okay.
guess the long and short of what I was going to say, Judge, is we just did our initial disclosure, so there has been no formal discovery that's taken place.
Okay. Judge Ancliffe, Chris Ancliffe, was one of my predecessors, and I hear him a lot. I mean, he's good, he's quick, he's efficient, but also on commercial type of issues regarding these, I think he's very good. So I'd like for you all to mediate with him, but I would like for you to, and I'll set a deadline, unless anybody objects to him. I'll set a deadline, but how much time can you mutually agree to right now that you need to have enough data to go to Chris, number one. And number two, we're hitting the holidays, so I'm not going to be setting any kind of deadlines between now and the end of the year. And then realistically, to get started up again, for me to, for hearings to get going and everybody to get resettled after their Christmas vacations, my dockets are starting up around mid-January and then running into the year. So I don't think it's that difficult for you to tell me if you can get all that you need for a good mediation in 3 months. Is it?
I'm not sure, Judge, because I've requested information 6 months ago and I haven't received it. So it's really incumbent upon Mr. Obregon to let me know when he can provide that information.
Okay, so Ms. Auger, I accept that, except that you both are professionals, and I don't think that you preparing for the next 3 months is any indicate that the 6 months that you've been waiting for information is any kind of indication. I am 99% certain that Southwestern Bell and El Paso Electric are motivated and able to do whatever they need to do to prevail on their claims. So, okay, you waited 6 months. That's between you and him. Unless you file a sanction or anything like that, that's between you and him. For me, I want to get the case moving. So I'm asking, yes or no? Do you think 3 months is enough for you all to conduct your discovery and to be prepared to mediate the case?
On behalf of the plaintiff, Your Honor, we would say yes.
Ms. Auger.
Assuming Mr. Obregon provides us the information that we need, that would be feasible, Your Honor.
All right, Ms. Auger, you can meet in my court, okay? But
Sure.
I'm on Zoom. Hold on, let me finish talking. I'm on Zoom, and I'm on live and all. I don't know, YouTube or whatever, and I try and conduct myself, and I do to the best of my abilities. I asked you a yes or no question, and you're qualifying it. So you are a party that I have control over, the lawyer, and so is Mr. Obregon, and he answered my question. And so my question is, can you do it or not? And if there's any reason you think you can't and you don't want to take the risk of getting a deadline, then tell me no. Okay, I don't want maybe.
In that case, no, Your Honor.
Okay. Would 4 months be enough for you to be ready to mediate? Ms. Auger?
I'm thinking through the holiday, Your Honor.
Excuse me?
I'm sorry, I said I was thinking through the holiday and where that puts us.
Look, Ms. Auger, it's a pretty simple question. You're a professional. You're a good lawyer. You
Thank
worked,
you.
I don't know if you're by yourself or you're still working for a big firm, and Mr. Obregon is. And why am I wasting everybody else's time? Because you're being fickle, excuse the term, about, well, maybe yes and maybe no. Tell me, please. I need information from you as as the lawyer in this case. If you need more time, and you tell me, if Mr. Obregon objects to that, I'll hear his objection. How much time do you need to prepare to be ready for a quality mediation?
To prepare for a quality mediation, Your Honor, we would request 6 months.
Okay. Mr. Obregon, is that all right with you?
That's fine, Your Honor.
Okay. I will set this in between for a status hearing, just to make sure everything's on track. And of course, you can file any kind of motions or sanction motions or attorney motions or whatever, either side, because the code provides for that, and I'll hear them. So let me see, 6 months. I'd like for you to arrange and go see Judge Ancliffe, I'm sorry, Chris Ancliffe, by the end of May.
Thank you,
Okay.
Your Honor.
And then, I leave it to your secretaries and your schedules and all to find a mutually convenient time to go to such a mediation.
Yes, Your Honor.
All right. I have just one or two related questions and comments. Not that they're, well, only so you'll know the degree of appreciation that I have. I know that there are a lot of lines that aren't being used, and I can see that there would have been a removal either on purpose or not so on purpose, or maybe with an understanding. So I can see how the controversy arose. Were these lines in an easement lines?
Yes, Your Honor.
Okay. Is there such a tort as abuse of easement?
If it exists, and I don't know one way or the other, it's not a claim that I've ever prosecuted, Your Honor.
Okay. Just a collateral inquiry regarding the topic. Thank you very much. And you can get, Robert will be giving you a status setting maybe sometime in late March or early April.
Thank
Okay?
you, Your Honor.
Thank you,
may
Your
I be
Honor. May I
excused?
be excused?
You may, and so may you, Mr. Obregón.
Thank you, Your Honor.
Thank you, Judge.
Yes, ma'am.
Have a good day.
You too. All right. Okay. Rina Ojeda versus Hawkins Self Storage. This is a motion to reconsider hearing by Mark
Morning, Your
Walker. Mr. Benjamin, good morning. Are you involved in this?
I've entered on behalf of Mrs. Ojeda and, yes, Your Honor, and
Okay.
Mr. Walker.
Okay.
Good morning, Your Honor. Mark Walker here for the defendant.
Okay. So it's a motion to reconsider what? No, so she's no longer pro se. Mr.
Correct, Your
Benjamin?
Honor.
Okay. And how long have you been on the case?
About a week, Your Honor, 10 days.
Not Mr. Walker, but Mr. Benjamin, is that who's been on
Yes,
the case?
Your Honor.
Okay.
That's
I just
correct.
entered and then we filed a response and then Mr. Walker filed a reply.
Okay, so the motion to reconsider is has been filed by whom?
I did, Your Honor. This is a motion to reconsider. We filed a motion to dismiss for warrant of prosecution. Earlier this year, back in February, we had a hearing on May the 1st. And I'm asking the court to go ahead and dismiss this case for warrant of prosecution.
Okay.
And I'm happy to get going on it whenever you're ready.
No, I want a live hearing in my court for that.
Okay.
So get with Robert and he'll set you up for a live hearing. It'll probably be in an afternoon around, 2 or 3, where I don't have anything else on the docket for that day. It probably won't be this year. It'll be in January. But the way Robert gets the settings, it'll be a mutually convenient time. Okay?
Very good.
Okay,
Understood,
thank
Your
you.
Honor. Be
Thank you,
excused.
Mr. Benjamin. Yes,
Thank you, Your Honor.
well, each party.
Have a
Okay.
good one.
GECU versus Mauricio Hernandez, a default hearing. Chris Black.
Good morning, Your Honor. I'm here on behalf of GECU.
Okay,
I'm filling in for Mr. Blaylock.
that's fine. And then the defendant never filed an answer and you're getting a default?
Yes, Your Honor, we're not aware of any answer that was filed.
All right. First, while I'm talking to you, I'm going to ask my court coordinator to look through the actual file, because sometimes pro se people will file a response and then you're relying on, I don't know what you rely on.
Understandable, Your Honor.
You'll be going through the file. When did you serve, Mr. Hernandez?
Yes, we had service on March 21st of 2024.
Okay. And then what's the nature of the it's deceptive trade practices. You filed the deceptive trade practices against Mr. Hernandez?
It should just be a contract claim, Your Honor. It was 2 loans.
Okay. But I mean, do creditors file deceptive trade practices?
Not usually, so I'm not sure why it's labeled as that.
It could have been coded erroneously by the clerk this time.
Understandable.
All right. So what's the amount in controversy?
Yes, so for both loans together, the amount owed by defendant to plaintiff is $48,456.96.
And what were the loans for?
There was one personal loan and then one loan for 2022 GMC Sierra, and that GMC was recovered and sold for, let's see, it was sold for $55,495,000 or $100, sorry.
Okay. Are both loans car loans?
No, the
What-
first loan was just a personal loan, Your Honor.
How much was that?
The personal loan was for about a little over $17,000.
Okay.
That was the amount financed. After all of his payments, the amount would have been a little over $29,000.
Mhm.
And the amount left on that personal loan is $23,395.60.
All right. Just give me 1 second.
Of course.
What kind of, did you get personal service or was it 106?
I believe it was, let me look at it was 106 service, it looks like.
And based on what?
Give me 2 seconds, Your Honor, I can tell you.
Yeah,
that
that's
answer.
fine.
Judge, this is Robert. There's no answer filed.
Okay, thank you. You heard that, Ms. Tompkins?
I did, Your Honor.
All right. Well, Ms. Tompkins, what I'm looking for is the probability or reliability of the method of service.
Of course, I understand. It looks like, Your Honor, that when we were attempting personal service, there was no answers at the door for the first attempt, but we saw his vehicle in the parking or in the driveway.
Okay, that's
And then-
enough for me. That's fine.
Okay,
That's
perfect.
enough for me. I've actually had affidavits that when I went into it, not only was there no answer at the door, but the house was empty.
Oh, no.
So-
Yes, on this one too, it looks like the process server also spoke to his wife. So it
Okay.
looks like this one might be good.
All right. And then, I mean, I signed it, I approved it, but I just looked into it. The oh, what kind of attorney's fees are you asking for?
Yeah, so it looks like Mr. Blaylock filed an affidavit of, for attorney's fees in the amount of $2,500.
Okay, that's reasonable to me for the amount. I mean, I used to do collections out of law school many decades ago, but all right. And then, what kind of interest are you charging?
Yes, so we're asking for post-judgment interest at the lower loan interest amount at 8.49%.
But did you tack on interest on the judgment? I mean, on the amount pre-judgment interest?
Yes, Your Honor. So
Much.
for the GMC, we were tacking on interest at 17.9%, which was the contractual interest for the vehicle. And then for the personal loan, there was that 8.49% interest.
I know. So how much is it? How much of this 48,456 judgment that you're seeking? How much of that is interest?
Yeah, so it looks like we have the exact amounts for you. For the vehicle, it looks like the interest was $4,599.66. And
Okay.
then for the other one, it was $2,269.06. So that was the interest that is added into that 48,000.
When did the loan go into default?
It looks like the last payment on the first loan was December 13th of 2022. And it looks like the last credit on the GMC was February 22nd of 2023.
You know, I'm not pro-consumer, okay? But on some of these, and I'm sure your contract covers this, but when was that person served?
He was served March 21st of 2024, Your Honor.
Okay, so you know, you waited this long, or maybe even if you attempted this earlier, you're not coming in front of me, and so a whole year has gone by, and you've tacked on interest when the creditor could have been a little more diligent, taking into account maybe not the car loan even, but just that it was a personal loan, and that the gap in the payments. Who knows what the notes were? Somebody trying to work it out. So.
Of course, Your Honor. It does look like we filed the motion May of 2024.
It
And
doesn't
so,
matter, Miss Tompkins. Yes, okay. Even if you can say it's on me.
oh no, Your Honor, I was not
No,
saying that. I
no,
was
no,
saying
I
the
know,
interest was
but
only.
you know, we're live here, so I need to explain, okay?
Of course.
Even if you can say it's on me when it got filed, the creditor should have been more assertive about getting a setting to get a judgment. And so
Of
a whole
course.
year went by, and then at the rates that you're charging, I don't know how much more was added, you know, has been added since that time. So what I would like to do is at this, the way that this is being requested, I want a live hearing.
Of course, Your Honor.
Okay, if you're taking into account what I have to say, and you're reassessing something, and you want to submit it where I wouldn't request a live hearing, that's fine too.
Of
I mean,
course.
you'll appear again, and then, you know, hopefully you or your Mr. what's his name?
Mr. Blaylock.
Mr. Blaylock will explain to me, and then I can make a decision that way. You are owed this much contractually, okay? I just want a live hearing so I can go into it with a little more detail, and then I have all these people waiting. Okay?
Of course, Your Honor, that makes sense.
So either way you want to do it, that's fine, and Robert will give you a setting.
Thank you so much, Your Honor. May I be
Yes, ma'am.
excused?
Thank you. Yes, ma'am.
Have a good day.
Thank you. Next. Oh, I'm sorry. I'm the one calling the docket, right? Okay. I have Wilma Jo Savage.
Good morning, Your Honor. Jeffrey Borshaw for the plaintiff, Miss Savage.
Okay. And then?
Good morning, Your Honor. Cindy Vasquez for the defendant.
Okay. Defendant. Michael Joseph Hernandez. So this is a motor vehicle injury?
Yes, sir.
Have you had enough? Oh, so you want a scheduling conference. Robert will give you a jury trial date.
That'll work.
And yes, sir. Thank you. But also, when did the accident occur?
I'll get that date for you in just a minute. Your Honor, it was November 15th of 2022.
Okay. How much time do you need? Do you have enough discovery to go to mediation?
I think we do. All we need is depositions, which I think we were at one point attempting to schedule that haven't gotten scheduled, but one deposition of the plaintiff and one of the defendants should get us to where we need to be to mediate effectively, Your Honor.
Okay. We have I don't know if you know Mr. Cardenas, a local mediator, but I'd like to refer you to him before the end of March.
Very good.
You schedule whatever you need to schedule, or hopefully you can settle it that way.
That'll be fine. Thank you, Your Honor.
Just for me, are there insurance companies on both sides?
There's an insurance company on Ms. Vasquez's side.
Correct, Your Honor.
So, Mr. Barshow, you're here for the plaintiff. Okay, all right, but it's not a subrogation claim.
No subrogation claim that I'm handling, Your Honor. If there's any subrogation, it'll be handled by someone else.
Okay, and then what's the amount in controversy?
Well, Your Honor, are you asking for the limits of the policy, or?
No,
Um,
sir, Mr. Marshall, I'm trying to get a bearing on the kind of case that it is. So I guess, Ms. Vasquez, does it involve personal injury? The litigation, not any claims that you have. Does it involve personal injury?
Yes, Your Honor.
Okay. And then, can you just tell me, well, no, I'm not going to put you in that spot. Okay, I got it. I know now what this is all about. So please go mediate it before the end of March. And then in the meantime, you'll have a jury setting that Robert, my court coordinator, will give you. And
Thank you.
intermediate
Works,
setting.
Judge.
Okay, thank you.
Thank
Thank you,
you.
Judge. Will be
You're
excused.
excused. Yes, sir.
Have a
Next.
good day.
Thank you. Next. Oh, James Larkin, DBA Tidal Wave Pools versus David Alvidres for a status hearing.
Judge Randy Ortega on behalf of James Larkin.
Yes, sir. How you doing?
Good, Judge, and yourself?
Fine, thank you.
And Robert Skipworth on behalf of the defendant, David Alvidres.
Okay. Mr. Ortega, can I still call you Randy? And Mr. Skipworth, can I still keep calling you Mr. Skipworth?
Please, Robert.
It's meant as a deferential compliment to each of you.
Well, thank you very much, Judge.
All
But
right.
Robert is fine. Mr. Skipworth is my father.
Okay. A status hearing. It's what's the nature of the lawsuit, please?
Judge, it's a dispute over pool construction. We've done discovery, we've done depositions, and Mr. Skipworth can correct me if I misstate anything. But I think we're ready to get sent to mediation. If it doesn't settle at mediation, I'd like to try it before you, either before the court or to a jury.
Okay. So both of you are established practitioners here. Offhand, does anyone come to mind that you would like to go to for the mediation?
I'm okay with Chris Antcliffe, I'm okay with Carlos Cardenas, and I'm okay with Mitch Moss.
Okay. Mr. Skipworth, Mr. Cardenas, okay?
I agree with Mr. Ortega on all three.
Okay, let me send you to Mr. Cardenas, and let's have your mediation by mid-March, the Ides of March.
Can we have it by the end of March, Judge? I have some stuff coming in.
Can do it by the end of
earlier in the year.
March, if that's okay with Mr. Skipworth.
That's fine, Judge.
All right, by the end of March, and then you're going to have your jury trial setting, and then let Robert know to schedule the jury trial early enough that I'm not going to be scrambling to try and get to try and be the judge on the case if you don't set it. Okay.
Yes, sir.
Thank you very much.
May be excused.
Thank you, Judge.
You may, sir, and so may you, Robert.
Thank you.
Excuse. Okay. State of Texas versus it's a non-disclosure by Brian Herrera. Nobody here? Nobody here. Okay, this is a no-show, but it's also a 2010 case. Robert, do you know anything about this or any ideas on how I should handle this?
I'll make some phone calls, Judge.
Pardon me?
I'll make some phone calls.
Oh, okay. Is this is like Brian Herrera for the county attorney or somebody? Something like that?
I'll have to look, Judge.
All right. Well, okay. We can talk about it after I finish the docket. DRB Capital versus Payee on a structured settlement in
Your Honor, David Little for the DRB Capital. And I believe Mr. Devin Estrada, the annuitant, is also online.
Yeah, I see Mr. Estrada. Okay. Mr. Little, where are you?
I'm in Pearland, Texas.
And what structured, what company are you representing that?
DRB Capital, the petitioner, Your Honor.
Okay. And then DRB, sir.
Correct.
No, I'm talking to him. Can you hear me? Your microphone's off. Devin Estrada, can you hear me?
Yes, Your Honor.
Okay. So the settlement is for a principal amount of for the contractual amount of how much, and the just the why is Mr. Herrera owed that money? If I may, for Mr. Little, please. Mr. Little, did you hear me?
Yes, Your Honor. The amount we're purchasing from him is 60 monthly payments of $2,000
Okay.
starting in
That's
August.
fine. I don't, you know what, Mr. Little, I'm cognizant of, the concerns about this being, public, and then, Mr. Herrera will start getting letters from people and stuff. So, but it gave me an idea of how much is involved. Mr. Herrera, how old are you? I'm sorry, Mr. Estrada, how old are you?
I am 22, Your Honor.
Okay. And what do you do for a living? Well, don't tell me that, but you're not under any kind of anyone's care. You're just an independent adult. Is that correct?
Yes, Your Honor.
Okay. So, is this one of those that it's my money and I want it now kind of sentiments behind your claim? Well, there's commercials, okay? Whenever there's a settlement on something and then a company comes in and pays you an amount to buy that, whatever caused that settlement, it's just you are familiar with how much is owed to you ultimately. You're familiar with why. You just want money right now. And money has a present day value that's reduced from the total amount. Do you understand what I'm saying?
Yes, sir.
Okay, so that's what this is about. This action.
Yes, sir.
Okay, what do you do for a living?
For now, I am working on to be like a mobile card detailer.
Okay, and you're from El Paso?
Yes, Your Honor.
Okay, and where'd you go to high school?
Montwood High School.
Montwood?
Yes, Your Honor. Yes.
The Rams, right?
Yes, sir.
Rams. Okay. So, Mr. Herrera, the legislature required companies that are in this kind of business to, they wanted to regulate them so they wouldn't take advantage of you. Okay? And so they prepared all of this. They made you an offer. You've already accepted. And they filed all the paperwork that they need to file. And then I, as a judge, review this. And if I see anything that, including your condition, that seems out of order, whatever, I would look into that. I think everything looks normal and fine. And I'm prepared to give you that, allow. Does he end up being the plaintiff on this, Mr. Little? Is this?
We're the petitioner, Your Honor.
Oh, he's a payee. Okay. So they filed this lawsuit just because they're basically saying, Judge, we made this offer and, look at it to see if it's fair, or if, whatever you need to do to see if Mr. Estrada knows what he's doing or whatever. And I'm telling you, Mr. Estrada, I'm satisfied that you do. And whatever agreement that they're proposing and whenever they're going to start the payments, I don't have a problem with that. Okay? So you need to say yes or no.
No, yes, sir.
Okay. So let me just put this on the record. Well, no, I'm not even going to make a record of it. So, Mr. Estrada, this is what you want. You've had a chance to review the paperwork, and you want the structured settlement and the payments are fine with you for your needs?
Yes, Your Honor.
Okay. I'm going to tell you one more thing. Maybe Mr. Little told you, maybe he hasn't told you, but there are people who look for these types of cases, try and find out who you are. Like this one, they in the lawsuit, you are payee. But then they want, it's like if somebody won the lottery, they want to write you a letter, or they know that you have some money and they're going to send out a solicitation. Was that explained to you?
Yes, Your Honor.
Okay. And do you have somebody to go to? Not
Yes.
that is not Mr. Little. If you have concerns about that, and before you do anything, I mean, do you have in mind somebody that you trust that you could go to if you get a solicitation like that?
Yes, Your Honor. I do.
And do you understand what I'm talking about?
About the payments and...
No, the payments are whatever the contract says. You know what the payments are, right?
Yes, sir. Yes.
And you know for how long you're going to get them.
Yes, sir.
And you know when you're going to get the first payment.
Yes, sir.
And in your mind and in your own personal financial needs, you've taken into account when you're going to get your last payment and it will stop.
Yes, sir. I have.
Okay. So I'm not asking you about that. I'm confident you're well aware of that. I was wondering if, I don't think he has an obligation to tell you this, but as part of that, does this company, try and explain to you what I just told you about people trying to solicit you?
About that, no, sir.
Okay, and they don't have to, but they know, and also they file their paperwork so that it's hard for somebody to find out who you are. That's why they put you down as payee and they didn't put your name. Okay?
Okay.
All right. Mr. Little, this is a standard contract that you've submitted to other courts without any controversy?
It is, Your Honor. We have met all the requirements of the statute, the disclosures, the notices to all interested parties in accordance with the 20 days the statute affords. Mr. Estrada was advised that he had the right to get his own independent person to represent him today. He knowingly declined that. He feels as if he understands the transaction himself. He seems like a bright enough young man. So we're just here before you, Your Honor, to make a decision.
Okay. And then, Mr. Estrada, you heard Mr. Little. You're in agreement with everything he has said?
Yes, sir. We had spoken before.
Okay. So I'll submit the paperwork to my court coordinator. And then if I have any questions on it, Mr. Little, you'll get a call. Otherwise, it should be signed, and next week is Thanksgiving week. I'll try and make sure we do it before then. But if you don't hear from us in 2 weeks, don't be shy about calling back.
Thank you, Your Honor. So you're just taking it under advisement for now?
No, I'm not calling it that. Well, it is under advisement because we're doing Zoom, and I'm going to look at the paperwork.
Okay.
But it's, I mean, I guess technically it's advisement. You do this, your company, your client probably does this so much that, it's just a submission of precedented language and compliance with the statute.
I understand, Your Honor. I've done over 5,000 of them over 25 years. So.
Yep. Okay. Well,
All right,
thank you very much. You're both excused, Mr. Estrada. If you have any questions about this, don't call the court, call Mr. Little on the delay, or if it's whatever time it's taking. He's your contact to that agreement. Okay. So call him.
Yes, Your Honor.
All right. Thank you.
Awesome.
Thank you, Your Honor.
You're excused.
Thank you.
Okay. Angelica Martel, individually and as a next friend of SG, an incompetent adult, and AG, a minor, against an insurance company. This is pro se?
Your Honor, Linda Samples, I represent Progressive County Mutual Insurance Company.
Okay.
And I believe Miss Martell is present, but she is unrepresented. Or I heard her earlier. I don't know if she's still here, but nonetheless, Your Honor, Progressive has agreed to tender its $500,000 policy to her. And so let me just kind of tell you what happened very briefly. On
Yes,
September
ma'am.
4th of 2023, Miss Martell and her family suffered a terrible accident that changed their lives. She lost her husband. She and her family members were injured. They had significant medical bills. And so we're asking the court to appoint Connie J. Flores as guardian ad litem to advocate on their behalf to address those medical bills and make the best use of those funds.
Explain to me, Connie Flores, she a lawyer?
She is, Your Honor. She typically represents plaintiffs where she's served as an ad litem in prior case similar situations, and we feel that she has the skill set necessary to zealously advocate on behalf of Miss Martell and her children.
Against your company?
Well, there's no dispute. We're tendering the policy, but to ensure that the liens, the medical debt is addressed and all liens are taken care of.
Well, Ms. Samples, okay. You know, policy limits, sometimes I'm sure Ms. Flores can do this if she's going to zealously advocate, but sometimes factually someone will make a claim that more than the policy limits are owed because of whatever happened in the procedure to get it or whatever. But Ms. Flores does that? She does review all that?
Yes, Your Honor.
Okay, I don't have personal knowledge of her. That's why I'm asking you.
Ah, yes.
And it sounds like you're in the industry. And then the ad litem is based on the status of the adult and the minor.
Correct, Your Honor. The adult has autism that prevents him from,
No,
making.
I understand. Yeah, I understand that. But so Miss Martell is suing as next friend.
Correct.
So whatever. I mean, she can do that, and sometimes they're not even suing for any damages themselves. Is she?
The policies for all of this, so it's both individually and on behalf of her two children.
Okay, so she also has a cause of action. Oh, these are her children, and she also has a cause of action.
Yes.
All right. When I appoint guardians ad litem where both sides have a lawyer, but there's a minor child involved, and then I'll appoint a guardian ad litem. The statute says that I'm appointing the guardian ad litem not to represent, but to review the settlement. Is this a different type of guardian ad litem that I'm appointing if I appoint Ms. Connie Flores?
No, Your Honor. There has been no lawsuit. We're just giving the family the policy limits.
I see. Okay. No lawsuit, but this is a procedure to protect your company from anyone thinking they might be abusive.
Correct. To ensure that the best interests of the children are represented.
Okay. So as Connie Flores, besides being a guardian ad litem, she could conceivably become the plaintiff's lawyer, or is she prohibited from that if she's a guardian ad litem?
I don't know. I presume she could be. I will tell you, Miss Martell had counsel early on, but they withdrew from representation.
Okay. Is Connie Flores a local attorney?
She is, Your Honor. She used to be with Flores, Tani, and Acosta. She's a plaintiff's lawyer. She's now gone on her own. She's Flores and Mendez.
I'm familiar with the law firm and the members of the firm, and So I don't have problems appointing her guardian ad litem. I'm just surprised she's not here, but I'll appoint her guardian ad litem. Oh, I'm sorry, not guardian. You want her? Yeah, you want her appointed as a guardian. Send me the paperwork and I'll sign it.
Thank you, Your Honor.
Okay, and if I have any questions, I'll let you know.
Okay.
Thanks.
Thank
Oh,
you.
Miss Samples, are you in El Paso?
Yes, I am, Your Honor. I'm with Robles, Bracken, and Hughes.
Oh, yeah, okay. I know them too. Should I know you or remember you?
I don't know that I've been in your court before, Your Honor.
Yeah. Okay. Thank you.
Thank you.
You're excused. Okay. Discovery Bank versus Maribel Ramirez. I got Christopher Munt for the plaintiff, and then pro se for the defense. Who's Maribel Ramirez? Who's here?
I'm right here. I'm right here, Your Honor.
How are you, ma'am?
I'm doing okay, thank you. How about yourself?
I'm doing fine, thank you. And then who's Mr. Munt or whoever is sitting in for him?
Yes, good morning, Your Honor. Gabriela Trujillo on behalf of the plaintiff.
Okay, and Ms. Trujillo, where are you from at?
I'm a local, Your Honor, El Paso,
Oh,
Texas.
should I know who you are? Sorry.
No, I just moved from Houston, so probably not. I'm still learning the different judges here.
All right. Well, you know, people come in and out, and if I ask them who they are, they're saying, "Judge, don't you remember me?" You know, so it's a courtesy.
I
Actually.
was born and raised here, Judge, so I'm happy to be back.
Oh yeah. Well, I don't hometown. That's also true. All right. So this is a breach of contract lawsuit.
Yes, Your Honor.
What's the amount of controversy?
Well, here's the thing, Judge. So at the time that we filed our motion for summary judgment, the defendant did still owe $17,962.39. However, she has been making voluntary payments every month, so I would be asking for a reduced amount now at this time in the amount of $13,333.39, including court costs and post-judgment interest.
Okay. Ms. Ramirez?
Okay.
She became pro se because she filed an answer, or?
She did file an answer, Your Honor, on October 13th of 2020.
Okay. So, Ms. Ramirez, I'm gonna ask you to go to mediation. Has it been mediated yet?
No, Your Honor.
Okay. I'm gonna ask you to go to mediation, and usually in a situation like this, the bank will pay for the mediator, but if you have a hesitation about that or whatever, we do have a volunteer mediation program, and you just try and fit in there as you can. But Ms. Trujillo, can I send you to a mediator that you're going to end up paying all of it for?
Your Honor, if I may respectfully, I don't believe that we need mediation in this case. If the motion for summary judgment isn't granted today, I would either ask for a bench trial or just a short reset so that I can get with defendant. Assuming she's already making voluntary payments, we can likely get a Rule 11 and agreed judgment on file.
Okay.
And we can go that.
But I also have an obligation. I also have an obligation to oversee that Ms. Trujillo, nobody's taking advantage of her. And I'm not saying that your firm is one that would, but that's my role here also. So what I would like to do is to have a live hearing in front of me so that I can ask all the questions that I need to ask. And then you can take whatever action you want to take. Like, for example, I'm hearing that she's been trying to pay it off. And sometimes it ends up getting settled that way. Or like you say, an agreed judgment just to make sure that it does get settled. But if Ms. Ramirez is not represented by counsel, I can at least take everything into account and, answer any questions that she has on what it is that she's doing.
Okay,
So
yes, Your Honor. I
never mind about
understand.
a mediation. Never mind about me. We'll set it for live here. Ms. Ramirez, you can come to court if you get an order to come to court at a particular time.
Okay.
Yes?
Yes, 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 Your Honor.
Okay. So you can always get a lawyer if you want, but you also have a right to represent yourself in this case. Robert, please give him a setting that's in the afternoon, so I don't have anything afterwards that I'm going to rush through that. Number one. And number two, Miss Ramirez, we're hitting the holidays, and I probably can't give you a setting until after late January or so. Is that all right with you?
That's okay. That's okay, Your
Is
Honor.
that all right with you, Ms. Trujillo?
I'm sorry, I didn't catch that, Your Honor.
I said, is that all right with you to have a hearing or a setting on your motion, or whatever it is that you're?
Yes, Your Honor.
Okay.
That's fine. My connection is spotty. My apologies.
Okay. You're too young to have hearing problems, Ms. Trujillo, like me. It is electronic. No, I know. Okay. So Robert will give you a setting, and then we'll proceed accordingly.
Okay. Thank you
Thank
so
you very
much, Your
much,
Honor.
ma'am.
Thank you, Your Honor.
Thank you.
Thank you.
Okay, you're excused, both of you.
Thank you.
Okay. Discover Bank versus Gloria Romero.
Judge, they filed something this morning, non-suiting the case.
Okay. There's an expunction.
Oh, Judge, my correction. I was talking about the expunction, not the Discovery Bank.
Okay. Thank you. Discover Bank versus Gloria Romero on a motion for summary judgment. Christopher Munt for the plaintiff and Oscar Ornelas for the defense.
Good morning, Your Honor. Oscar Ornelas for Gloria Romero.
Okay. And Discover Bank?
I'm glad I stuck around, Your Honor. Christopher Munn is someone from Swicker and Associates. I did not have that one docketed, but I have your docket up. If I could have a brief minute to pull up the cause number.
Okay. And then Ms. Trujillo, I just want to make sure you're the same Ms. Trujillo that was here earlier, but I don't
Yes,
see
sir.
you on the Zoom.
Sorry.
Okay, so Ms. Ornelas, while she's looking it up, can you just brief me on the debt?
Your Honor, may it please the court.
Yes, sir.
So this case is a 2020 case, Your Honor. The parties went to mediation. We entered into a Rule 11 agreement back in December of 2020. Discover Bank was required under the terms of the Rule 11 agreement to file the Rule 11 agreement with the court. They never did that.
Okay.
In the meantime, my client has been making her monthly payments and has reduced the amount of the debt significantly in accordance with the terms of the Rule 11 agreement. But for some inexplicable reason, Zwicker and Associates decided it was a good idea to proceed with a motion for summary judgment that they filed prior to entering to the Rule 11 agreement. That now, so where we are right now is that we have a breach of the Rule 11 agreement, and we filed a Fair Debt Collection Practices Act claim and a Texas Debt Collection Acts claim because Discover Bank breached their agreement with us.
Okay, Mr. Ornelas, let me stop you right there. Did you file those causes of action into this lawsuit, or
Yes, Your Honor.
filed separately?
No, we filed it in this cause of action.
Okay, so Mr. Trujillo, I don't even know if and Mr. Ornelas, I know there's a way to find out and all, but I just want to get down to the crux of this. Because a new cause of action has been filed, and if your files don't show that, I'll reset this for a status, not for your, well, I mean, if you come in here or you tell Mr. Ornelas, well, we're also proceeding on the motion for summary judgment, let him know. but I just want to get a status because this is kind of an unusual result. Sometimes Mr. Ornelas is inexplicable, but also mistakes are made. And so let me just get a status hearing that Robert will give you. Are you both in El Paso?
Yes, Your Honor.
Okay, well, let's have it in El Paso. And Ms. Trujillo, you can do it if you can manage that. Get the same setting date that you have for the other case that I put you on. And go ahead, ma'am.
If I may, before we schedule this, I hear opposing counsel's frustration, but if I can just verify, I mean, if a second motion for summary judgment was filed after we had already filed or didn't file a Rule 11 and agreed judgment, that had to have been an error. But I want to confirm.
Wait, hold on, Ms. Trujillo. Ms. Trujillo, let me stop you there, okay?
Yes, my apologies.
I heard what he said, and I'm the one who'll determine, who has a right to have a frustration or not, but now's not the time. It's a lawsuit in my court, and I'm going to drive it the best way I can so that both parties, I can dispose of this case efficiently, and both parties have an opportunity. So please, what I'm trying to tell you is I want to see you in person. That'll give you time for you to look into the case, or if another lawyer in your firm is handling it, they can appear, and then let me take it up that way. Also, there's nothing that precludes you all from discussing this unusual situation or possible mistake before you get to me to judge over what kind of damages there might be or attorney fees or whatever. So
You're right, of course, sure.
Please see if Mr. Ornelas can make it a mutually convenient setting for you all to be there on the same date that your other case is on, because you'll already be there. I need to see this in person, Mr. Ornelas.
Yes, Your Honor.
Okay.
Now, will the setting be 1 month from now? Will hit us right up to Christmas.
No. You're not. I'm not going to set this. I mean, you may be in a rush on it or whatever, but I can't. I'm not setting anything until after mid-January, because after 15 years on the bench, people are coming back from holiday and all this and all that. So, and y'all can accommodate that. I know that. Even if you can't, you must, because that's my schedule. So
I was only trying to get a sense of when that setting was going to be, but if it's going to be in January, that's fine, Your Honor.
Well, when do you want it, Mr. Ornelas?
It's subject to the court's discretion, of course, Your Honor.
Well, that's why I'm telling you. I knew it was, but you're asking me, when do you want it? If you want it, it could be February or March. When do you want it?
No, mid-January would be fine, Your Honor.
Okay. There might be a line for that, but Robert, give them as early a setting as you can, where I'm going to be around in the afternoon, and I can take it up as the last hearing. And then on the previous case that Ms. Trujillo is on, you can tack that one on too with a pro se party. I don't think it's going to take that long on that one. And then any motions that you need to file before your hearing, file them. Civil rules, what is it, 10 days before, or you have to give the other side an opportunity? Mr. Ornelas, you're not going to be filing anything else because you already have it filed. Is that correct?
We filed our counterclaims, Your Honor, back in November, well, earlier this month. Okay. So we will be filing our own motion for summary judgment this week.
Okay, so in that case, Robert, schedule it at the end of February or the beginning of March, so that Ms. Trujillo's firm can have enough time to go over it and see who's going to handle it or whatever. And I don't think, from what I hear, that it's going to be a big hardship, other than, I don't think it will. So do it at the end of February or beginning of March, please. Okay?
Thank you, Your Honor.
Yes, sir.
Thank you.
And then both of you, you're going to get, Robert's going to send you dates, and then you both sign off if you can agree to a mutually convenient one. Is that the way you still do it, Robert?
Yes, sir, Judge. If one of them will send me the request and CC the other, that way I can send it out to them.
Okay, so let's have Ms. Trujillo send you the request, and she'll CC Mr. Ornelas. Okay?
Thank you, Your Honor.
All right, thank you. You're excused, both of you, on this case.
Thank you, Your Honor.
Ms. Trujillo, if you have another case.
I'd stick around, Judge.
All right.
I'm clear docket.
Okay, thank you. I have
Thanks, Your
here Jessica Bencomo versus YISD. And I have Ashley Cedillo as a plaintiff and Kurt Paxson as defense counsel. Is that correct?
Yes, Your Honor. Good morning.
Good morning, Your
morning.
Honor. This is Cindy Vasquez. I'm appearing on behalf of Mr. Paxson for defendant Isleta Independent School District.
Okay. How's Mr. Paxson doing?
He's doing well. Thank you for asking. He's just really busy.
Yeah, I'm sure. He's always sending other people for him.
Yes.
It's not a criticism. I know Kurt and he was dad. All right. Motion to compel. So who filed the motion to compel?
Yes, Your Honor. The defendant filed the motion. Since the defendant filed the motion, Ms. Cedillo has supplemented discovery responses and answers and has supplemented authorizations. I spoke with Ms. Cedillo this morning, and she is working on getting the defense additional authorization. So I think for the most part, we've wrapped everything up here. We just need to submit an agreed order to the court.
Okay. An agreed order on a settlement or an agreed order on the motion to compel?
On the motion, Your Honor.
Okay. So have you been to mediation?
No, Your Honor. And if I may, the parties are already talking about mediation. I've been talking with Mr. Paxson. We're going to be using Carl Green. It's just I have another case with Mr. Paxson, so we're hoping to reserve Carl Green for that whole day so we can knock out two cases on the same day.
Ms. Cedillo, did you ever work for Carl Green?
No, I did not.
Did you know that he's a partner? He used to be a partner of Kurt Paxson.
Yes, Your Honor, I did.
And you're fine with that?
Yes, and I spoke to.
He's a great lawyer, okay?
He is, and he's a wonderful mediator. And
Okay.
I know that's a concern. I've spoke to Mr. Green about that, and he's.
It's not a concern for me. For me, it's just that you got your eyes wide open. So I'll go ahead and please go to Carl Green and give him my regards. And you think that you can mediate this? Is March, the end of March, okay?
I think so, Your Honor. Especially.
Okay, so let me do this. Robert will give you trial dates after that date.
Your Honor.
This is yes.
I'm all for mediating this early. It's just that right now we just received the authorization today, and I'm just skeptical to tell the court that we would be ready to mediate by March, just because it's been taking a long time to get medical records in when we request them. So I think maybe April or May would be a little bit more realistic.
Okay, Ms. Cedillo?
Your Honor, I do know we just got another set of discovery requests from opposing counsel like last week. So the parties can still continue discovery, and we'll work this out with Mr. Paxson.
Right.
Agreed, Your Honor.
But I'm gonna give you a jury date that you can work against. And of course, you can always file a continuance or mutually reset it or mutually pass it. And in the meantime, I just don't want it to fall through the hoops. That's the way I do it. So Robert will be giving you a jury trial date in June or July or whatever month you want it. That's close to when I got a jury coming in. And then in the meantime, I would ask you to mediate it by the end of June.
Yes.
And then of course, if you can't, or if you're going to change that and just set a hearing or let me know, or you can both agree to pass it to, I do want you to mediate it, because that's also what's going to get it moving for it to get settled or tried. All right?
Your Honor, is there any chance that at this point that I could probably request an August trial date?
Yeah. Just tell Robert.
Okay.
I mean, why don't you send the request for the trial dates and tell him that you need it or want it in August, and then Ms. Vasquez will go over it. I'm sure with all the business they got and all that they're just going to put it on their calendar, but maybe I'm being too presumptuous, Ms. Vasquez. But anyways, I'm excusing both of you, and that's the way I operate here in my court. All right?
Your Honor.
Thank you, Judge.
All right.
Thank you, Judge.
Yes, ma'am. Okay. There's an expunction here? Oh, the attorney's going to be late. All right.
I believe he's already
Your Honor,
here.
Pardon?
This is Jed Unterrecker with the County Attorney's Office, and we're actually, we are here.
Okay. I'll get with you in a second. Lone Star Title versus Juan Manuel Duran. Anybody here for those parties? I have Mark Davis. Oh, it says in-person hearing. Robert, so is that going to be switched to an in-person at a later date? Robert, did you hear me?
Yes, sir, Judge. The docket, it's at 1 o'clock today, Judge.
I'm sorry, I didn't understand that.
The hearing is in person today at 1 o'clock.
Oh, thank you. They moved it from 10 a.m. Zoom to, well, that's great. I'll see them today at 1. All right. I'm sorry. No, you're right. It's at 1. Well, I'm already on the 1 o'clock portion of the docket. Is there anybody left here that hasn't been taken care of that thought you had a 10 a.m. setting?
Yes, Your Honor. Stephen Lucy here on behalf of the plaintiff, Daniel Garcia, for a scheduling conference.
And in what case is that?
That is 2025 DCV 2438, Daniel Garcia. I'm representing Daniela Labinotti's office.
Okay.
And this is against Manuel Garcia Sandoval.
Yeah, I have so many notes. I thought I had already called you because the notes from the other case, the Southwest Bell and El Paso Electric, bled down into yours. Who's here on besides Daniel Garcia versus Manuel Garcia?
Your Honor, Daniel Hernandez on behalf of the defendants.
Okay. And this is for a scheduling conference, meaning that you want to get a trial date, and Robert will give you that. But the other thing, have you all been to mediation?
Not yet, Your Honor. We're in the beginning process of discovery.
Okay. And what is the nature of the case?
Your Honor, this is a commercial case. Our client was backed into by a semi truck. And so that's something that I want to discuss with the court. I'd like to make a motion to require this to be under level 3 discovery because of the complex nature. We're going to be hiring experts. This isn't appropriate for level 2 or anything else. So I'd like to make this motion on the record, or ask that the court, under their own initiation, set this as level 3 discovery.
Okay, Mr. Hernandez, any objection?
Your Honor, by the fact that we're asking for a scheduling conference and a scheduling order, it makes it at level 3.
Okay, so send me an order.
Yes, Your Honor. I'll draft one and send it over to Daniel.
And then get Mr. Hernandez to sign off on it.
Your Honor, does the court have its own template that it wishes that we follow?
Did you please repeat that?
Your own template for a discovery control order, a scheduling order?
No, I don't have a template. I just go with the settings that you all want to have. Although I don't get that many level 3s. If a party wants to submit a scheduling order and you can both agree to it, I'll sign off on that as well. Thank you.
Very good.
Yes, Your Honor.
I think that'll take care of that today, won't it?
Well, we need a trial setting, Your Honor.
Okay. So when do you want to try it?
9 to 12 months from now, Your Honor.
Okay. I'll schedule it a year from now. I can make a better assurance of trying the case if you want me as a judge a little earlier than that. But you can always reset the case. So Robert, give him a jury trial date on the second half of next year, wherever I got the juries coming in. And now you'll have a jury trial date to shoot at. Is that all right?
Yes, Your Honor.
Very
Okay.
good, Your Honor. Thank you.
You're both excused, and one of you needs to send an email and copy the other side to Robert for whatever settings you're trying to get.
Yes, Your Honor. I'll send the email.
Okay.
Thank you, Judge.
Who's Carl?
Judge.
Oh, Carl Jones. Thank you. You're excused. Carl
Thank you.
Jones is here with whom?
With Jed Unterrecker, sir, on the expunctions.
Okay. I think this is the last case I have, but I also have a Zoom user. Ma'am, I don't know who you are, but do you have a case here that is the expunction?
Yes, Your Honor. My name is Paloma Martinez. I'm here with Pro Se for the expungement.
Okay. On what case?
It is the DCV 3652, the tampering with government records.
That's a crime.
We had actually scheduled because we met back in person the last time.
Yes. Okay, I remember you now. You want to expunge that and you work for CPS or something like that?
Yes, for HHSC. Yes, sir.
Okay. Mr. Unterrecker, do you know anything about this?
I do, Your Honor. So Jed Unterrecker, Assistant County Attorney. I think a couple weeks ago it was Ms. Cherie Shapley that was here supervising Carl. Ms. Shapley is in mental health hearings right now, so it's myself here. I am familiar with the case, and Mr. Jones is prepared to answer the questions that the court had at the last hearing for you.
No, I'm going to do this live.
Okay.
I'm sorry, what's your name, ma'am?
Paloma Martinez, Your Honor.
Yes, she's been down here. She's presented her case. I had concerns about a possible writ. And
Yes.
if you're over here because you're still not wanting to grant her what she wants, I want to have a hearing in person.
Okay.
Okay. I heard about some things that could have been discrepancies. So you need to be in person to explain to me how those discrepancies don't exist.
Your Honor, can
Yes,
I
go
say
ahead, ma'am.
something real quick?
Sure.
I know that they had reached out to me saying that there was no records found, so they were going to go ahead and come back and say that there was no records found on the previous case, and that they were going to go ahead and if you agreed to the expungement order to approve it, that they weren't going to rebuttal that.
Your Honor, if I may.
Your Honor, let me just jump in. Yes, the petitioner is correct. You had previously asked Mr. Jones and Ms. Shapley to look into whether or not there were documents that still existed. We did that, and the petitioner is correct. We found no documents on this case. As well, in talking with the petitioner, we don't know how you're going to rule on it, but we did tell her that generally this is a case that we don't typically appeal. Ultimately, that's the county attorney's decision. That's not our decision, but that's generally how we treat cases like this.
I need to find out if I'm authorized to appoint someone to represent her.
Okay.
This is a criminal matter, and she needs a lawyer on this. Based on what you all are telling me, that can, if there's something to fight you on, they can fight you evenly. Okay? And then I have a lot of respect for Mr. Jones, but I am not going to allow him to participate on this particular case.
That's absolutely fine, Your Honor.
Yeah, and Mr. Jones, no, don't take it the hard way. It's a very complicated issue. And, well, actually, you sat in on the other one, right?
I actually addressed you on the first one.
No, right.
It did not go entirely smoothly, but we did
No, it
discuss
did.
the case.
It did. Justice, I mean, I'm sitting down there and I have a little more insight, I believe. I'm board certified in criminal law and I'm a little familiar with some of that stuff. And it's a complicated issue. So
Yes, sir.
I just want to know if she is indigent, whether I can appoint a lawyer to represent her on a writ issue.
Yes, sir.
Okay.
Okay.
So, and then I don't want to do it here on Zoom with everybody listening to this. If you Robert, set it for an in-person hearing, And, you know, I know Mr. Unterrecker is right across the hall. And ma'am, I don't know how hard it is for you to get down here, but if you can come down here at a time that Robert can, you know, so I can address you all live,
Yes, sir.
I can do that. And I don't think that I need to set you off for a long time. I just,
We can go. I know this is of big importance to the petitioner, and I think time is of the essence. So we can do it whenever you need to, or whenever you can do it. So
that's what I'm saying, Mr. Unterrecker. I want to see you in person, and Robert will give you a setting. And ma'am,
yes, Your Honor.
when you come in, I also need to figure out. I mean, if you want to hire a lawyer, you can, but I also need to figure out if you're indigent and you can't afford counsel. I think this is a case that that you are entitled to a lawyer because you have a criminal action, criminally related action, where you have a big interest in the case, a personal interest and a constitutional interest. I already forgot some of the things that were infirm, but if you all get down here, I can define them, and I'll have a court reporter, and we can go from there. For example, Mr. Unterrecker, were you there? You weren't there.
I was not there, but I was fully briefed by Ms. Shapley.
No, I know you're fully briefed, but so let me explain to you, okay? Mr. Jones and Ms. Shapley came in and they told me something that made a lot of sense if you're a lawyer. But I don't necessarily think that. I'm sorry, ma'am. I keep forgetting your last name.
Martinez.
Martinez. Okay, but I don't think Miss Martinez understood. So I don't know if I was told that I can whatever decision I make, it's not going to get appealed. Well, that's a different consideration that I have in making it, and it's a different form of acquiescence because of the weakness of the case or the tenuousness of your claim, and the fear of violating Ms. Martinez's rights. But that's usually lawyer talk. I didn't expect her to understand that. That, for example, if that is what they were suggesting, because we talked about a lot of stuff. If that is what they were suggesting, and you can ask Mr. Jones because it happened in chambers, then they could have been saying, you know, your office was saying, look, Judge, we leave it up to you, and we'll let you know if we have the records or not. And if you deny, if you grant her the expunction because of the missing records, we're not going to appeal it. That wasn't clearly told to me, and I don't think that Ms. Martinez, you know, she reiterated some of that stuff, but I may just get the public defender to come down and step in on this very unusual case, so that if there's lawyer talk like that or whatever, it's not done because I compelled it or that I participated in any kind of plea bargaining. It can be done arm's length with me, and her lawyer with the public defender's office can talk to you. And if that's, you know, this is not going to take a long time.
Agreed.
But it could take a long time if it gets appealed as a writ. And that's what I'm trying to figure out is, you know, if I do a writ, it's going to have to get filed as a separate civil case. And Ms. Martinez has a job. She's done a great job, you know, with her petitions and all that. And guess what? It was even as an afterthought of us talking about me granting it, that she said something that it's like, holy cow, maybe there is an issue here. So instead of you having to deal with her pro se to explain to her all this, let me see if I can get somebody from the public defender's office to represent her on the hearing, and then I can go from there. And maybe so let me see. Robert set it on a docket where I'm going to have my criminal docket, and where the public defender is always there. And then, Mr. Unterrecker, I'm going to find out if I can appoint somebody to represent her. The main issue on representation of counsel is the taxpayers are paying for it, and then if I give her a private lawyer, they're going to submit a bill. If it's a public defender, they serve the county besides serving defendants, and a bill's not going to get generated where taxpayers have to pay out of pocket. That's what I'm thinking right now. Okay.
Sounds good.
Okay, so it'll be set. You seem to have a concern about how soon this needs to be done, Ms. Martinez. What was that?
Yes, Your Honor. So there was a breach in within the agency, and they're doing fingerprint background checks for
Okay,
everybody.
okay. Robert, if you think you can file it, get a setting today's. Do I have a criminal docket tomorrow?
Yes, sir, you do.
Okay, let me see if I can do it tomorrow in the morning. And so, what time should Ms. Martinez be here?
The docket starts at 9 o'clock, Judge. And it's gonna have to wrap up soon because the DAs will be leaving soon.
Oh, well, the DAs aren't involved in this, but yeah, okay. And so let me come in tomorrow at 9. You might have to wait, Ms. Martinez. And then let me appoint from the bench then.
Yes, Your Honor.
Okay? Mr. Unterrecker?
Your Honor, that works for me, and I hope Ms. Shapley can Ms. Shapley can also be there too, because I know she's got expertise, and Mr. Jones will be there for his moral support.
No, yes. I'm all for him standing by. I just didn't want him, Mr. Jones was very diligently prepared. And then he came up to me afterwards and he said, Judge, thank you for suggesting that angle that I hadn't figured out. And but I think he's going to be a fine lawyer once he gets licensed. And he's a good, I don't know if he's an intern or whatever he is, but we need good lawyers here. I know the DA needs them. I know the county attorney needs them.
Yeah, no, he's a licensed third-year law student, so we're happy to have him, and he's getting good experience.
Yeah, so let's do it that way.
Great. So we'll be there tomorrow then at 9, Your Honor, and ready to get this resolved.
Oh, and one thing, you don't mind if I ex parte somebody from the public defender's office to explain the controversy so that
I don't mind at all, and I'm also happy if there's somebody I should send documents to, I can get them over the petition and the.
Well, why don't you send them just offhand? Because I'm thinking of the 2 lawyers that are assigned to my court. Why don't you send them to Robert? Remind me of his name, Mr. Ballesteros. You know Mr. Ballesteros?
I don't, Your Honor. I can find him. I can find him on Teams though, and send it to him.
Yeah. The only thing that I'm worried about is that if it's Friday and he was by chance not going to be there, but I'm going to be talking to him and go ahead and send him the paperwork.
Okay.
Okay.
That sounds good, Your Honor. We'll see you tomorrow morning.
Thank you very much.
Here, everybody. We'll see you tomorrow.
Thank you, Ms. Martinez.
Bye.
Bye-bye.
Okay, I'm leaving.